This week, the United States Supreme Court issued a landmark ruling dictating how anti-discrimination employment law provisions apply to people who are gay or transgender, which will change the landscape of anti-discrimination for people within those classes for the future.
How does this apply to real estate? Find out on this episode.
Welcome back to Talking Real, brought to you by the Oklahoma Association of Realtors. This is episode 124 of Talking Real in the studio with your hosts, Jeff and Nabil. Nabil, sitting here having some coffee with my friend Nabil. Nabil, how's your day?
This good. Kind of feels weird recording this on a Wednesday.
Yeah, we're a day behind here, but that's okay. We're still bringing you this week's episode of Talking Real.
That's right. And most people wouldn't listen to it until Wednesday, right?
Exactly. So all is well. So I apologize when I told you last week that we'll see you next Tuesday. Turns out it's Wednesday. But hey, you know what? We're still here, and by golly, we're not going to miss this week's episode.
By golly.
Yes. So real quick before we get started with our topic of the week, we do want to make sure everybody's aware if you're planning on attending the Region 9 conference. We've been pitching that for quite some time now. It had to be rescheduled due to COVID related issues, and so we rescheduled it. And because there's been kind of a recent seeming spike of COVID cases coming up, the Region 9 trustees met and decided that we would actually be canceling it this year. We may have some other related things coming up, so if you were planning on attending that, just be looking at your emails that we're sending out for a lot of good reasons. When we send out those emails, we want you to take a look at them. But Region 9 related, just be looking out for some other alternative things that may be coming up. But the in-person conference is being canceled. So just wanted to give you a heads up on that if you were planning on joining us for that. Unfortunately, we're having to cancel that this year.
Yeah.
So
it is unfortunate. Sounded like it'd be fun.
COVID sucks.
Yeah, the hashtag COVID sucks.
But anyway, so this week we wanted to talk about a United States Supreme Court case that just came out this week. This is kind of a big deal. This is what us in the legal community call a landmark case. It's funny, but I mean, this is the kind of case that law students will be studying for years and years to come.
Like this is what they call case precedent.
Yeah. So this is absolutely huge precedence, and we'll talk about what this has in store for the real estate industries. Why are we talking about it today? But what we're talking about here is the case of Bostock versus Clayton County, Georgia. And just to give you a little history, a real quick overview of what we're talking about. This is a case where it deals with employment discrimination. Specifically, these cases dealt with people who are homosexual or transgender, were the specific cases. So this is actually 3 different cases that were all put together into one. So this is, if you look how cases get to the Supreme Court, what ends up happening is people go to federal court, they sue somebody saying that their rights are being violated or whatever the issue is. In this case, it relates to Civil Rights Act of 1964 violations. And the district courts that people sue in, if they win or lose, the other party, the losing party, will generally appeal that up to the bigger district court. So you're looking at an appeals court that is in between the base district court and the Supreme Court. And so you'll have multiple cases that come up out of different parts of the country, and they all eventually get appealed up to the Supreme Court. And finally, after years and many, many appeals and many instances where the Supreme Court says, no, we're not going to take up this appeal just yet, eventually, after there's lots of precedents all around the country and there seems to be a split in the various districts and parts of the country, then the Supreme Court will take up the issue and finally hear it.
So it's not just like a one-time thing.
Rarely.
It has to be an issue and a persisting issue for the Supreme Court to say, okay, let's look at this and give a ruling.
Exactly. And a lot of times what you see is a split in the various circuit courts. And so the circuit courts are what people appeal up to. So that's what's in between the district courts that are in each state and locally. And then that goes up to the circuit courts. And once there's a split in circuit courts, multiple circuit courts have weighed in, maybe on multiple cases, then the Supreme Court can take all that precedence and settle the issue. So
is it common for multiple cases to be combined into one?
Absolutely. This is very common because there are, various plaintiffs and cases across the country. They get appealed up to the Supreme Court all on a common issue. Then the Supreme Court will lump those together and say, we're taking these 3 cases, combining them into one, and this will be the ruling that we issue.
And this will serve as a basis for all other cases.
Exactly.
Like
so then it's settled. There's no more question. If somebody were to go to a district court, the district court would be obligated to follow this precedence. Same thing if it got appealed up to the circuit courts, you would likely have to follow that as well. So there is how a case gets settled by the Supreme Court in a very quick overview. So this is something that has been brewing for quite some time. Obviously, there have been discrimination issues for people in these categories for quite some time. And so this is that big landmark case where the Supreme Court has finally weighed in and decided the issue. So to give you the very quick backstory, and this is just coming from the opinion, what the backstory is of these cases. So in each of these cases, an employer has allegedly fired a longtime employee simply for being homosexual or transgender. In one of the cases that it's named after, Clayton County, Georgia, fired Gerald Bostock for conduct unbecoming a county employee shortly after he began participating in a gay recreational softball league. The second case, Altitude Express, fired Donald Zarda days after he mentioned being gay. And RG and GR Harris Funeral Homes fired Amy Stevens, who presented as a male when she was hired after she informed her employee she planned to live and work full-time as a woman. So you've got the issues with being terminated for being homosexual and an issue for being terminated for being transgender. Each of these employees sued alleging sex discrimination under Title VII of the Civil Rights Act of 1964. And so once these went up through the circuit courts, they sided with various people. The courts were split, and ultimately this came up to the Supreme Court. And the Supreme Court has now held that an employer who files an individual merely for being gay or transgender violates Title VII of the Civil Rights Act of 1964. So what this means is, what it says there, that if somebody is terminated simply for being gay or transgender, that person now has a right to pursue a claim with the EEOC and potentially other civil lawsuits against that employer for terminating them for sex discrimination. Prior to this, sex discrimination was basically, I'm firing you because you're a woman or because you're a man, right? It's essentially based on just purely that gender discrimination. Right. And so this expands it. And the two sides to this issue, and again, I'm not just kind of what the sides argue, is the side that is sort of opposed to this says, well, the law says sex discrimination. It says a lot of other things too. So this also deals with employment discrimination on the basis of race, on the basis of national origin, those kinds of things that we're all pretty familiar with, right. Very similar to the fair housing context. But this is all employment related. And so one argument is that, well, sex is simply your gender assigned at birth. That's what we're talking about when the Civil Rights Act of 64 says you can't discriminate on the basis of sex. And on the other side, the argument is that when you are considering terminating somebody because they are homosexual, transgender, that necessarily involves consideration of their sex. And that in turn then means you're discriminating on the basis of sex, because you can't get to that decision until you have considered what their sex is and use that as a basis.
Because it's a transient property.
Yeah, so it's that
it relates to that at the base level.
Absolutely, right? Absolutely. So that's sort of the very high level overview. This is like a 100-something page opinion with a 50-page dissent and
Thanks for
everything else.
Not reading all of it.
Yeah, so you're welcome to go read all of it, but there's a lot of articles out there that give you some analysis of how they got to this decision.
And if you're interested in that, we'll include a link to that in the show notes.
Absolutely, yeah.
So it'll be easy for you to access.
You bet. So the question was, why are we talking about this today? Well, for really a couple of reasons, because it does relate to real estate. Now, this particular case is purely in the employment context, okay? But I want to draw a corollary here to Article 10 of the Code of Ethics that we have, because I think that this is interesting for a couple of reasons. I think we should just read it, Nabil.
Let's do it. Yeah, because discrimination or protection against discrimination is not new for realtors.
Absolutely not.
We've had this in our Code of Ethics for 10 plus years, right? It's been a while.
Right.
So
I think that it was in 2010, NAR amended the Code of Ethics to prohibit discrimination in real estate based on sexual orientation and gender identity in 2013. So the realtors have actually been way ahead of this for quite some time now. And specifically, Article 10 says that realtors shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. It also says that realtors in their real estate employment practices shall not discriminate against any person or persons on those same bases. So we've had that in the Code of Ethics for quite some time, that we don't discriminate on the basis of sexual orientation or gender identity in either real estate practices or in employment practices. Yeah. So I think that's kind of interesting how long we've been kind of ahead of the game on that and have been a part of that. But it's interesting now to see then the Supreme Court has now weighed in and made this part of the law of the land. Mm-hmm. So this is kind of where we are.
Yeah. And in the standard of practice 10 part 3, it also relates to advertising. So it says realtors shall not display or circulate any statement or advertisement with respect to selling or renting of a property that indicates any preference, limitations, or discrimination based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity.
Right.
So, I mean, I think it encompassed you can't advertise or discriminate against advertising, employ, and serve.
Right. Absolutely. And, this is just interesting because what NAR did by including it in the Code of Ethics specifically is basically what the other side of who was arguing against this decision is what they argued. They didn't, even Justice Kavanaugh, who's the most recent Supreme Court nominee, he wrote a dissent and he acknowledged that this is a very big win for the proponents, and they should be happy about that. His opinion was, though, that this is something that Congress should have done, that gender identity and sexual orientation are not within the definition of sex. And so Congress should have changed this as opposed to the Supreme Court weighing in. And that's kind of what NAR did with the Code of Ethics is, well, then we'll just put it in specifically because while it is technically legal to discriminate against people in these contexts based on the current law at the time, we're still going to hold ourselves to a different standard that we are not going to discriminate against these people. And if we do, then that is a violation of our Code of Ethics. And that's the interesting thing, is that it technically was legal to discriminate. Now, it was not permitted by the Code of Ethics for, realtors in both employment and in the real estate practice in the housing context. But now it's broadly illegal in employment. So I think that's really kind of interesting. And so the question is, how does this then translate to housing? Because the Fair Housing Act, this case was about the Civil Rights Act of 1964, Title VII, which is employment. And the Civil Rights Act of 1968 is where we actually have the Fair Housing Act. That's where the discrimination based on the prohibition on discrimination based on sex comes in for housing. So how's that going to translate? Well, obviously the analysis is the same. So I think you can pretty safely say that, look, based on this case that came out, it is now illegal to discriminate against somebody who is gay or transgender in housing because of this same kind of analysis that we have. So if somebody is in property management, or they're, you know, a landlord, or somebody's wanting to sell and they're making some sort of statement about wanting to discriminate against somebody on these bases, not only can you say, well, as a realtor, I'm prohibited from doing that by our code of ethics. That's something that is strictly against our code of ethics. But based on the law as it is today, if you discriminated against somebody on that, you are very likely to be the next test case, and the Supreme Court will tell you that it's also illegal in housing context. So I think it's safe to say, based on this reasoning, that the Supreme Court, if they look at it as a claim under fair housing, would come to the exact same conclusion. The analysis is identical. It is exactly the same, basically. And so it's pretty safe to say now that other contexts where we say that you can't discriminate against somebody on the basis of sex, this case would work as precedents to show why that also now includes gender identity and sexual orientation.
Right. So I guess that once that test case happens, which is, I mean, inevitable, right? It'll happen and it'll get formalized. But for the cases of practice, you should just treat it as it being illegal.
Absolutely.
And not necessarily our members, because we've had that in our code of ethics from the start. But, you know, in general, if you see someone doing this, you'd be like, hey, man, check this episode out.
Yeah, exactly. So, you know, will an actual fair housing case come up before the Supreme Court? I mean, I don't know. It may never be necessary, because now, you know, you can have district courts and you can have the EEOC that would use this.
They could look at that and it wouldn't escalate
and
to
so
that.
you now have at that lower level, this has been settled. And so it certainly could. I mean, I could certainly see cases where it could move its way up to the Supreme Court. It wouldn't surprise me. People are always willing to have those kinds of test cases, sometimes on purpose, because they think that they might be able to get the law changed. And we see that a lot with various other issues that come up. But yeah, I think we can definitely say at this point that it is a settled issue that sex discrimination includes gender identity and sexual orientation, which is just interesting to have that settled, and how that applies. And again, how NAR and the realtors have been kind of at the forefront on this. I mean, in 2016, NAR adopted a motion to actively seek legislation that includes sexual orientation and gender identity as protected classes under the Fair Housing Act. So we've been advocating for this for quite some time, and believe that this is the right result. So just kind of interesting. Wanted to share that. I'm sure most people have probably seen it at this point. It was pretty big news, but we're also in a world where every day it seems like there's big news about something. So I wanted to make sure nobody missed that, kind of understood the background of it, what it means, and kind of how it applies, and where the realtors have been on this issue, because we've been championing that issue for quite some time.
Yeah.
So that's what I got, Nabil. What do you think? What do you know?
I know what you know. That is also a transient property.
Yeah. You know, that is a little bit in the weeds, right? It's sort of a deep dive in some Supreme Court case law. But again, I think that applicability to the real estate industry and everything is worth talking about. So I think it's fascinating. It's interesting because we study these cases when I went to law school that happened, you know, into the past, these like seminal landmark cases that deal with various types of discrimination issues, right? We're all familiar with Brown versus Board of Education, which occurred in 1954, which is the Supreme Court case that said all public institutions and schools must desegregate with all due haste. We're familiar with, in fact, just recently we celebrated the anniversary of Loving versus Virginia, which was a case that said that states that have laws that prohibit interracial marriages. They struck that down. We actually just a week or two ago had that anniversary. And so we see these sort of seminal civil rights type cases come up. But it's been a while since we have this kind of a major shift, landmark kind of case. And so as a law nerd, it's certainly fascinating. And again, I think for realtors who are on the forefront of looking at discrimination issues and constantly having to learn about discrimination issues and make sure that we're not engaging in those kinds of things, it's a good case to understand and kind of be aware of.
Yeah, for sure.
Like I said, I could go on all day talking about these kinds of things.
And he could. He's holding back right now. I can see it.
He's just on the edge of my seat. So anyway, wanted to bring that to you. We hope that was informational and you have a little bit better understanding. And we'll put a link in the show notes to the actual case if you want to go read it, and the statement from NAR that they released. So you can take a look at that as well and see a little bit of our history there. So
yeah. So as always, if you found this information useful, please share this episode with a fellow real estate or law nerd in this case.
Yeah.
And spread the love of Talking Real.
Absolutely. We appreciate it every time you give that share. And make sure you're subscribed. And if you have any feedback for us or any kind of questions you have for us or anything else that you think, please make sure you email us to podcast@okrealtors.com, and that's where you can reach us. Well, that's going to wrap it up for this week's episode of Talking Real. And until next time, we'll see you next Tuesday, probably,
hopefully,
on Talking Real.